Harvard is on the wrong side of history, and Harvard has a choice. The purpose and the content of the complaint is to challenge Harvard's practice of offering preferential treatment in the admissions process to applicants with family ties to wealthy donors and alumni, so those so-called legacies. And we are challenging those practices because they are discriminatory and they harm the equitable access to higher education for people of color. Title VI of the Civil Rights Act of 1964 requires that organizations and programs that receive federal funding from federal agencies not discriminate on the basis of race. Applicants with donor and legacy preferences are 6 to 7 times more likely to be admitted to Harvard, and that 70% or nearly 70% of those applicants who are admitted through those preferences are white. We also know that removing legacy preferences will increase the admission rates for applicants of color. So because of the disproportionate impact that Harvard's admissions policies and these donor and legacy preferences have on applicants of color, that's the violation of Title VI. Lawyers for Civil Rights has always had concerns about donor and legacy preferences. In terms of why the federal civil rights complaint names Harvard in particular, and as opposed to other schools, what we know is that the affirmative action litigation involved Harvard, and that Harvard was required to produce extensive data on its admissions and applications materials. So from those extensive materials, which we would normally not have access to, we're able to make a particular case that is specific to Harvard's admissions practices because we know now what the data shows. The Department of Education has very broad powers with respect to policies and ensuring compliance with schools that receive funding from that agency. So what we could see is Harvard be an example. We at Lawyers for Civil Rights hope that these donor and legacy preferences will be eliminated on a broad scale. Numerous schools across the country are using these donor and legacy preferences, and they are overwhelmingly beneficial to white applicants, whereas there are very qualified applicants of color who are being denied access. So what we hope is that these practices cease to exist in order to ensure a level playing field for applicants of color, frankly, a level playing field in general. What we know is that these donor and legacy preference practices is that they're entrenched, that they're long-standing, that they're part of many schools' so-called traditions. But that does not mean that those traditions are right. It doesn't mean that those traditions can't be improved upon. It doesn't mean that those traditions should stand.